everyone. I'm Annette Pinyazik. I'm the Director of Grants and Major Gifts for Houston Area Parkinson's Society. Thank you guys so much for joining us for our second quarterly estate planning education webinar. We launched this series in response to requests from our community members about estate planning. So our presenter for this series is Kathleen Wiesenthal. She's an attorney with Keever and Wiesenthal. And Kathleen's practice focuses on probate, real estate, and estate planning. And today she's going to talk about powers of attorney, the types, responsibilities, and obligations of these roles. Now, we have reserved some time for questions and answers after Kathleen's presentation. So you can add your questions for Kathleen at any time. If you go to the Q&A, and we'll then answer them at the end. And today's webinar is being recorded, and a link will be available at the HAPS.org website and also on our HAPS YouTube channel. So Kathleen, I'm going to leave it to you, and I'll be back when you're finished. Thanks a bunch.
Kathleen, you're muted. So if you'd like to unmute and start again.
There we go. Okay, I'm here now again. Good afternoon, everybody. I'm very glad that you're here. We have a lot to cover today on powers of attorney. So I'm going to get started right away with my slideshow. Like they said, like Annette said, we are going to have time for questions at the end, and I will make sure to stop in time for anybody who does have questions. We're going to be talking about powers of attorney today and documents that might make you think you have power of attorney today. The power of attorney is very clearly something that is incredibly powerful. There are three types of POA. One of them really isn't a power of attorney. It only goes one way. There's a statutory, durable power of attorney, which does nothing to tell you exactly what it is for. What it is for is financial and legal matters only, okay? The medical power of attorney is obviously for medical issues. In the state of Texas, you are two people. You are your corporeal being, your person, and you are your estate. Even if you only have $100 in your checking account, that's your estate. And the statutory durable power of attorney allows somebody to act as your agent, to act on your behalf, not on their own behalf, to take care of any of your financial or legal matters. And I include legal in there because there may be people who are, entered into contracts that have to be dealt with during the time of their incapacity. And we'll cover how that works in all of this. The HIPAA release is that one-way document that, so I'll go back, sorry. The HIPAA release is a one-way document where it only allows the agent to be able to get information, but it doesn't allow the agent to partake in any decision-making. So the HIPAA release does give the agent some ability to be able to contact medical, pharmaceutical, insurance companies, things like that, to help the incapacitated person. Now, a power of attorney, all of these powers of attorney are usually only effective when the person that has signed them and turned over their agency to another person, when that person is incapacitated, then the agent is allowed to perform whatever duties they've been asked to do by the incapacitated person. Durable power of attorney is not something you do with permission from the person who is currently partially incapacitated. like for instance, my husband, who's perfectly fine, can't say to me, hey, would you just, get in here and deal with all the bills and all my personal finances and things like that and make decisions for me? No, that's not going to work. He either has to be incapacitated, which would give me the power of attorney, or there has to be a darn good reason why he can't do it himself. Statutory durable powers of attorney can be given to be active immediately, but that still only means that if the incapacitated person or the person who is the principal of the power of attorney, the person who actually signed it to give power to an agent, if they cannot make their needs known or are not available to make any decisions. Now, if you're going into just a real estate transaction, for instance, there's different powers of attorney for that. You don't need the statutory durable for that. You can actually have a power of attorney that has a short lifespan, and you will be allowed to help sign documents on behalf of that person, etc. But those are the, we'll get into more of this in a few minutes. I know I'm probably making it even more complex, but it really isn't that complex. The POA, the power of attorney, I'm just going to refer to it as a POA for the rest of the webinar. You cannot use a POA to sign a POA. So you can't give somebody else agency for the incapacitated person or the principal. We'll call them the principal because they may not be incapacitated completely yet. You cannot use a POA to sign another POA for the principal. You don't have that kind of power, okay? If the POA states that it is effective only upon the principal's incapacity, that's when it takes effect, not before. And the way you know whether or not the principal has incapacity is a doctor's letter or a physician's certificate. There are several ways to legally have proof by a physician or by a medical professional that there is an issue and that the principal is not able to take care of their own affairs. Making decisions for a principal may be made only as the principal would have decided. An agent has a fiduciary responsibility to prevent waste, so you can use your own judgment for making sure there's no waste to the estate, like an account that is getting 0% interest and you'd like to move it or something like that in order to pay for the principal's health care. But the agent cannot make up their own rules as they go along. If the principal all their lives has been giving gifts to their grandkids every year, that's something you might want to consider to still do, and you may have directions from the principal to do that. That's something you still can do if the estate allows it, if you've got enough money in the estate, but you can't make your own mind up about what you're going to do. You do have to work with what the principal would have done in the first place. Obviously, there is not always a way to know exactly what the principal wanted to do in the first place. And you will, that'll be a struggle. It's not an easy question to answer, but you will have to make some decisions on your own. But most of the time, you're supposed to be using the principal's standard, even if you don't agree with it, okay? The HIPAA release I just explained is a special kind of document that allows information to flow to the agent and will be effective only for health information, but not for decision-making. A HIPAA will never be any good for decision-making. So if you take it to a pharmacy and you say, I have a HIPAA release to pick up their medication, you can ask information about the medication and about the dosage and things like that, but you can't decide not to fill that, okay? That's not your responsibility. So, all right, hold on just a second. Okay. Okay, I was gonna be in the middle of it. Okay. Go ahead. Charlotte knows the login, thank you. Okay, I'm so sorry. There was a robbery in front of our office recently, and the police have stopped by to pick up my camera on my phone to get the information from my phone as to what was on the camera way back when. So, all right, I'm so sorry for the interruption. All right. So let's go to the statutory durable power of attorney first. That is one of the most powerful tools that we have. It protects your estate. Now, I'm talking to the people who are supposed to be signing a power of attorney to give an agent, okay, the information that's necessary. The power of attorney, the statutory durable, is not an assignable power of attorney. When you designate someone, let's say your spouse, and if your spouse cannot do this act for you or has any issues with the act, they are allowed to refuse to do the act. But if there is no alternate agent designated on the form, you can't decide to do that. You can't decide to give somebody else power of attorney. The agent cannot do that. The principal can. And we'll talk about capacity on being able to make those kind of decisions in a few minutes. It does require verification with a principal. If you, for instance, you're selling a house, the title company is going to call the principal and ask them if they in fact are alive and incapacitated. They're not going to flat out ask if they're incapacitated, but they'll say, we have someone here who's using a power of attorney to sell your property. Is that correct? And then, you know, if the principal completely denies that, we'll deal with that as it comes up. But it is not to be used unless the principal has authorized the transactions involved or the principal is incapacitated. If the it is the fiduciary responsibility, which has consequences. You, as an agent, you are taking on a great deal of responsibility. You are completely 100% responsible for anything that goes awry in the estate. And if like one of the children sues to say that it's being mishandled or something like that, you're going to have to prove that everything you've done with receipts and bookkeeping is all the way the principal would have done it in the past anyway. If the principal is incapacitated and cannot make any of these decisions to add a new agent or to authorize the use, it can be very tricky. The incapacitation is a pretty high bar for a statutory durable power of attorney. As an attorney, if I were to visit with somebody and they could tell me what their assets were, who their children are, who they're designating as an agent, why they're designating them as an agent, I'll feel pretty comfortable that they know what it is that they're accomplishing. And I will ask them straight out, do you understand what it is you're embarking on at this point? If a person cannot understand the transaction, I will not do a power of attorney for someone. There are attorneys who might. I do not. Let's move to the medical POA. It is a more fluid document. So for instance, in the durable power of attorney, if you're using that at a bank, let's say, and the spouse can't be there, but one of the kids goes and he goes, well, my mom has power of attorney and I'm coming in her place to help do this. They're not going to accept it. Done. I mean, unless they get a verification from the principal, it is not going to be accepted. It's only acceptable to use that if you are the actual stated agent on the transaction. Many times, but not all the time, if there are two agents, a primary and a successor, if the successor is acting on that power of attorney, the primary will have to actually furnish some kind of something in writing that says that they're unable to complete this task at this time for whatever reason, and that they would like the successor to take over. Medical power of attorney is a lot more fluid. The hospitals and insurance companies, doctors, EMTs, the primary agent is who they will ask for first, but successor agents are easily substituted in for the primaries at any point. The agents can make decisions for the care, if authorized by the POA, to other documents prepared by the principal. So if, for instance, they're entering a nursing home, they may be able to use a medical POA to take care of any documents that they have for a nursing home, to set them up, and medications and the necessities for living in a nursing home in a safe environment. So medical power of attorney is a little bit more relaxed. Now, some people will say, well, they talk to me without a medical power of attorney, the doctors will. And that's very true. When my husband was in the hospital, nobody asked to see my powers of attorney. They just assumed I had complete control of being able to deal with some of the issues that came up. And it depends on the doctor, depends on the hospital system. But they can refuse, even if you're the spouse, they can refuse to let you have any input if you don't have a power of attorney on file. If the power of attorney is a statutory format, then it is to be accepted by third parties. There is a statute in the estate planning, in the estates code, that allows people to prepare the statutory form, and it has to be exactly like it is in the statutes, for third parties to rely on this form. If this form that you have, or somebody else drafted it for you, and they didn't put the statutory language that was needed, third parties can refuse to accept it, but they must give you a reason why in writing. And they don't have to do it that very minute, but they do have to give you a reason why. And if it's serious enough and this is an ongoing problem, you can appeal that third party's refusal to take the POA. Could be the POA is not statutory and they can't rely on it. Or their legal team just won't allow that. The legal team in a place like a bank or an investment firm or something like that, they'll review your appeal and the reluctance to accept it, and then you will be granted the right to use the POA unless it's not a statutory form. I mean, if you just kind of did one off the internet, you don't know what you're getting, even if they call it that. Okay, so be very careful. And agents really should be located where the principal is located, but you don't have to be. But you really need somebody who can walk into that bank and sign something, because the bank is going to want a wet signature. They're not going to accept this over the phone. Can you imagine how easy it would be to commit fraud if they would just accept stuff over the phone? It's not going to happen. So especially banks and investment firms, things like that. So an agent really should be in the same town at least, or the same county as the principal. I wouldn't recommend putting your son who lives in Colorado as your POA. That's going to be very, very difficult for you to try to push that through and let a bank accept it. What you're thinking about is not how it makes it easier for you, although you are. You're thinking about what third parties have to accept, and the third parties also have to indemnify themselves against any liability, such as fraud or theft or anything like that. So keep that in mind when you're doing your POA and preparing it for your loved ones to do. You want to be very sure that it's going to be accepted by the third party. I'm trying to think of any other third parties who probably won't let you use that. It's mostly going to be a bank. A bank's going to give you a really hard time. In fact, the law, when it went into effect that third parties have to accept the POA, the bank lobby immediately said, well, no, we get to appeal. And then if it goes through our legal department, then we can review it and then we'll accept it, but only after it's gone through legal. So you're talking a couple of weeks worth of time. Don't expect everything to just fall into line just because you have a power of attorney. And when you have no other authority, such as a joint tenant with rights of survivorship on an account, then it's going to be very difficult for you to do anything without a power of attorney. When you have no other authority, if let's say your spouse has an account that's only in their name and you are not on that account in a joint co-owner scenario, then you will have to have a power of attorney in order for you to be able to get into that account and work with it, which is why I counsel people to please go and address all those issues with your joint accounts, separate accounts. Now, if you have a separate account because it's separate for a reason such as inheritance and or a gift from family, and you want to keep it separate so it doesn't become community property, I totally understand that, but then you've got to have some kind of power of attorney in place for them to be able to get into that account should it become necessary. And then usually that's upon your incapacity. Prepare to have an original for a third party when you go to a bank or something like that, but always make sure to keep possession of the original. They may ask for it and they may make a copy of it, but they have to return the original document back to you. There are not multiple originals. I've had people ask me that, and you can't do that. It's just one original, and you can make copies for your family or whoever your agents are, but the principal must keep it must keep the original, and a third party always has the right to ask for that original and make a copy of it. A principal very likely will be contacted by phone or mail or something, asking if it's okay for this person, this agent, to act on their behalf. So be available for that. If you know your spouse is going to be going to the bank, or if you are the spouse going to the bank to use a statutory durable power of attorney, either take your spouse with you if they're capable of going physically, or make sure that they've got a phone nearby to be called and asked. I know with title companies, they definitely ask for that. You may use the power of attorney maybe even for complex transactions if you're doing real estate transactions, selling some properties and so on. If you file it in the probate records, I'm sorry, the real property records of the county that you live in, that's probably going to be good enough, or in the county where the property is located, that's probably going to be good for a third party too. They'll see that it's on file. And if it's ever been revoked, it has to be revoked and filed on file. Keep in mind too, this is something that's actually pretty frustrating to a lot of people, is that powers of attorney can be revoked at any time, anytime. So if your principal has an issue all of a sudden with having the power of attorney out there, they can do a revocation. And then a revocation, like for instance, I always file a revocation even if there's not an original already filed in the real property records. And the reason it's on real property records is because that's where people know to look for power of attorney, people being third parties. It's good to have it recorded in the real property records if you have one. But again, keep in mind, if they revoke it, they have to revoke it in writing. But if they have revoked it in writing and you have a wet signature on a document that says they've revoked it, that will be sufficient to revoke it also. A third party has a lot of leeway whether or not to accept that. Okay, the medical power of attorney. This again is about you personally, top to bottom. This will allow an agent to make decisions for the care of the principal, but not if the principal is alert and communicative. You can't just say, oh, I'm gonna let my wife decide. You can't, no, you really shouldn't do that. It should only be when you are out of it, incapacitated, unable to speak, unable to write, something to that effect. It really, you don't want to have your agent making decisions that you can make medically and physiologically that you can make. If you can write something down, you can still make a decision. A principal can appoint several agents on a medical power of attorney, even if some of them are not in Texas. Now, this is where I tend to differ with it on a statutory durable power of attorney. My own opinion is that on a durable power of attorney, you want somebody who's here in the county, in the city, wherever you're going to be using this, because it can be used, because this is a digital world, it could be used long distance, but oftentimes it's a lot more effective if the agent is able to make themselves personally available. Again, fraud. Just think fraud. There's not a third party who's going to be comfortable with that, and they have the right to refuse to accept it too. In the medical power of attorney, you can probably appoint people who are not physically within the state. Now, that sounds odd because you're thinking, well, if they're not there at the hospital or the EMTs or something, how would they be able to help? Well, sometimes your family members do know what's necessary. They can remind the doctors or the EMTs exactly what medications you're taking and what kind of conditions you have and what they should be looking out for in the event that you're not capable of doing that, to communicate with your health professionals. Now, this does not supersede a directive to physicians. If you have already, and that's something we'll go over in I think it's the next webinar. We'll be talking about directive to physicians, which very briefly is your document telling your family and your physicians and your medical professionals what your wishes are in case you become terminally ill or irreversibly ill. If you have a medical power of attorney that says that I'm never to be left to die without life-sustaining treatment, but you did a directive to physicians that says you will be willing to forego life-sustaining treatment in cases of terminal or irreversible illness. The directive to physicians will take control. Again, it depends on the hospital, depends on the doctor, and it depends on your insurance company too, perhaps. And your family needs to understand what your wishes are. You got to be real clear about those things. And if you have an attorney that's preparing these for you, make sure that the directive doesn't contradict the medical power of attorney. You really don't want to do that. Now, the medical power of attorney usually doesn't give you those kind of choices, but there are spaces for you to write in instructions in a medical power of attorney. So that's what I'm referring to really, is people who are going to put instructions in that power of attorney. All right, then we've got final tips and takeaways. Keep in mind that you've got to exercise patience with third parties. You cannot expect them to just do this because you've slapped down a power of attorney. That's not appropriate. Third parties have their own information that they're going to be needing, in their own circumstances that may be required for their insurance, for their legal reasons. The statute doesn't always keep up with every corporation or every entity's legal reasons for wanting to tape these documents. So you've got to have some patience and understanding with why they're not accepting it, and trying to see if you can rectify the situation. Contacting your attorney is a good place to start so that you can see if the right language is where you need it to be. but those are handled like a one at a time situation. Knowing when you can or cannot use your powers of attorney, regardless of what third parties tell you. So keep in mind that if you want to be really clear about when it's appropriate for you to use your power of attorney, consult with your attorney on that. Again, it's very different for different situations, but you don't want anybody flat out telling you, no, you can't use your power of attorney. Well, they need to tell you why, and you need to talk to your attorney and find out what is missing or lacking in your powers of attorney in the legal document that makes the third party nervous. With a bank, like I said, right off the bat, they'll say no, and then you have to deal with that aftermath. All powers of attorney are revocable, medical and statutory. So if you think you've got it locked in as a spouse of an incapacitated person, and you say, oh, well, they gave me power of attorney, I'm the one. Well, they can revoke that at any time. And so you have to be real sure you have that power of attorney that you hold has not been revoked already. And you cannot, it is void and useless if it has been revoked. Okay, so you got to be real sensitive to that. I've got notes in here that you can use you cannot use a power of attorney to revoke a TOD. A TOD is a transfer on death deed, or you cannot use it to revoke a ladybird deed. So for instance, a spouse cannot revoke a TOD or a ladybird deed, which are used for real property in Texas, used to convey real property to as a gift or inheritance. And the power of attorney cannot be used to revoke those. That's not your place to do that. Whatever has been done by the principal before you took power of attorney cannot be changed. You don't have the right to back something up like that, and you're putting yourself in harm's way in terms of individually for self-dealing or for lawsuits. And you want to be very careful and not to undo what an incapacitated person has already done. That also means that you cannot use it to change an estate plan. No. Somebody says, well, I need to change my husband's will. No, you don't get to do that. If your husband no longer has capacity to change his will, then his will won't be changed. His will stand as it is, or you will have to probate his estate as if he had no will if you can't find a will. A spouse or a child does not get to come in and tell me, for instance, how to do their parent or spouse's will. No, it doesn't work like that. I don't do that. Remember, you'll always use a standard of judgment that the principal would have used. This is not your chance to rewrite that person's life. Absolutely not. And I'll tell you, if I get the feeling that I've got people who are about to do that and about to wreak havoc with somebody's estate plan because they're using a power of attorney, I will put a stop to it. And that is not what it's for. You're there to assist the principal and to talk about what it is that they want, need, and are used to. You'll know when it's time to make other types of decisions when that person is incapacitated, but that's something for you and an attorney to talk about. That's not for you to decide unilaterally, okay? Now, one of the other things I wanted to bring up is that guardianship. I know you've all heard about guardianship. If you have powers of attorney for an individual and they lose capacity, you probably don't need a guardianship. 99% of the time, those powers of attorney will be all you need to place them in care, to take control of their finances so that you're able to pay for their care, to do any of the things, decide where they're going to live, decide who's going to take care of them, how often that person's going to come in to take care of them. Those are the things that you're allowed to do with a POA. Now, guardianship, that's the step in another direction, but the same It's the same basic idea. A guardianship is only necessary if remember I told you that powers of attorney can be revoked. So let's give you a scenario. The wife has been given powers of attorney by her husband. He loses capacity and becomes very, very ill. And his mental processes are such that he fights everything she says. And he flat out refuses to let her be his power of attorney anymore and wants to keep wandering down the street. And the police can't pick him up unless he's broken the law. And you want to put him in a safe place where he is not going to be, subject to harm and will be looked after, but they don't want to go to an assisted living, memory care, whatever it is. Those are that 1% of the individuals that you're going to probably have to get a guardianship for. I'm not saying it's a given, but because you have to apply for guardianship with the court, and it takes a while. It's not a fast process, it's an expensive process. And you have to take classes, and you have to pay a bond, and you have to report financial. If you become the guardian of the estate of the person, you're going to have to make sure that you've accounted for every single penny of their money that you've spent. That puts into question the management of the community property estate. There's a lot of things to be involved in something like that. And if you're a child doing it for a parent, a guardianship is something that the courts are going to, the courts want this to be a very pure process. They don't want you don't want to get a guardianship for somebody just to put them in memory care because you want to force them to stay in memory care because it's easier for you. Okay. That most likely isn't going to pass by a court for a proper guardianship. There's a lot of factors involved. You need to talk to an attorney about that. But the powers of attorney that you have on paper, if they haven't been revoked, they're going to be hugely helpful in getting care and taking care of your loved one who is incapacitated. But keep in mind, there are those moments where it's not going to be as easy. And that might be a necessity for a guardianship. And again, those are all very individualized. There's not one black and white road to go down to decide what's going to be the path for somebody. And sometimes just because of the way the law is written, you may not be able to be a guardian for someone. If you're a felon, you cannot be a guardian for someone. If you are, have ever been convicted or even just charged with, and I think this is a correct, if I'm wrong, I'll apologize and send out a note, but you can also not do it if you've ever stolen anything or been accused of stealing anything. And that takes into consideration your actions while you're taking care of this person. If there's cash deposits missing from this individual's account while you've been a POA, you might have to do a lot of proving up before you're going to be able to be a guardian. So, I mean, a guardianship is very, very protected, and the courts are very careful about that. Guardianships are taken very seriously by the courts and by the county in general and the state in general. And they will not give guardianships just because you don't have the means to take care of that person anymore. But an attorney would be able to, I say we as attorneys, a probate attorney would be able to discuss all of that with you and find out what your options are. I'm stopping just a little early, and I can address some other issues to see if there are any questions.
Thank you so much, Kathleen. We do have quite a few questions. One of them I'm going to address before we get to the questions for you, Kathleen. Someone wanted to know if they can get a copy of the broadcast, today's broadcast. It will be available on our HAPS website and our YouTube channel. If you go to haps.org, at the very top, to the slightly right-hand side, you'll see some logos. It's next to the logo that is for Facebook, and it will take you directly to our YouTube channel. And we have for quite a while had the copy of the broadcast from your first part of this webinar series. So give us at least a week or so and we'll have it up and on the website, so or on that link, so you'll be able to get it there. Let me get into the questions that I certainly can't answer. Um, let me see. Somebody wants to know, Kathleen, if you can please address the dual power of attorney.
Yeah, and a dual power of attorney means that the principal has already named two people to serve as co-agents. If there's somebody designated as the first agent, and then there's a second person designated as successor, the only time that successor can use their powers is if the first agent has written a letter saying they're not available and cannot be the first agent at this time, that they have to resign or step back. There is no such thing as a dual power of attorney unless you have co-agents, which means the two agents have to work together. Everything they do has to be signed together, taken together. It isn't like, oh, you do this and I do that. It's a lot more serious than that. If you are doing tasks for an incapacitated person right now as, let's say, just a favor. I have a lot of people that come in, their neighbor helps them do their accounting or pay their bills. That's not a power of attorney. That's just helping somebody. And sometimes as a spouse, that's what you're supposed to do. Basically, I mean, that's what the law considers is, hey, you're the spouse, you should know what everything that has to be done. So you just do it. If there is somebody already as a primary agent on a power of attorney, they should be doing the work. They should be doing it. And don't put yourself in a responsibility position that counteracts that power of attorney, because you may be leaving yourself open to fiduciary in liability. So.
All right. Next question is somebody wants to know if you could reiterate the part about about the POA agent being in the same town, state, etc. They want to know what happens if you don't have anyone nearby.
That happens a lot. Okay. I think what I should have said was it's preferential. It's preferred that the POA be in the same location as the incapacitated person. If you're the daughter of an incapacitated dad and you're the only person he has to trust to deal with all of his financial matters, you're going to work that out with his custodians of all his money. If it's an investment firm, if it's a bank, if it's CDs, credit union, whatever, you should already have that worked out, copies of your power of attorney on file, so that they have the comfort zone of dealing with you and not having to go through this as if it were the very first time. Okay. It doesn't have to be here. There's no law that says you have to be here, but it's very difficult to perform a power of attorney unless you're at least here once or twice to meet with the bank, meet with the financial advisor, things like that, to at least give them the security of knowing they're dealing with the right person.
And can your spouse be your executor on your POA?
There is no executor on a POA, okay? And that's terminology. So an executor is a person who executes a will that's been probated in the probate courts, okay? And they're only an executor if that will's been probated. An agent for a power of attorney is the person that can help do any of the matters that are necessary for financial and legal reasons. The agent can be a spouse, absolutely. 90% of the time it is a spouse or the children. if you're gonna have co-agents, we were just talking about co-agents, remember that they have to do everything together, and that's not most desirable. But a spouse can be an agent on a power of attorney, either for medical or for the durable power of attorney.
Okay. Do you need a DOA for electronic records such as email, etc., credit cards?
Yes, that is in the powers of attorney that I put together, the durable powers of attorney, that is included in there. And also in the wills that I prepare, I give an executor the ability to be able to deal with any of the digital assets that there might be. And a digital asset could be your Facebook login, or shutting off Facebook or Twitter or whatever. But yes, there are several ways to make sure that that's handled.
Okay. And do you file your POA in real property records in the county where you live or where the property is, or both?
It wouldn't hurt to be both. Usually, if you're going to do it in one place, do it where the property is.
Okay. And lastly, I shouldn't have said lastly. How does the SDPOA work with Social Security's Form 787 Physician's Medical Officer Statement of Patient's Capability to Manage Benefits?
That would be one of the forms that you can use to prove incapacity.
All right. And now, again, lastly, can a person refuse to be an executor of a will after the principal's death?
Absolutely. Absolutely. You're not forced to. You may refuse. And if the attorney drafting the will gave the executor the power to appoint an administrator. Okay, let me explain that a little more too. So you've got a will. The will says that Dorothy's going to be my executor. Nobody else is listed, no successors, nothing. Dorothy doesn't want to do it. Dorothy's already 90. She's tired, doesn't want to do it. And if the will says, well, if Dorothy doesn't want to do it, she can name an administrator, which means they won't be an executor. The powers differ slightly, but they differ. Okay. So if you're named in the will, you're an executor. If you're not named in the will and you apply to probate a will, you're applying to be an administrator. Okay. You can only be an executor if your name's already in the will. Okay. Or the executor that is chosen selects you under directions in the will that says that they can choose you or choose an administrator. Okay. Did I make that clear, or did I just muddy that up?
I have a couple of questions for you for clarification. So if
Okay.
somebody, for whatever reason, cannot be an executor of someone's will and they choose to have somebody that they have appointed, what is the legal process for them doing that?
There's actually what would be called the waiver of, let me see, is it the waiver or a declination, either one? But it's a document that you file with the court that says, I've been named as the executor, but I have to decline for whatever reason. But the will in paragraph blah blah has given me the ability to appoint an administrator. I appoint my niece, who is really excellent. She knows the family, she knows the background, and I think she would be a good administrator. Now, what happens is that that appointment by the executor, or that agreement by the executor, is not enough to appoint that person. You still have to go through the process with the court. And they have to be vetted through the court and made sure that they don't have anything conflicting with the estate and things like that, and to make sure they don't have a felony, that kind of thing. But that's basically what that would happen. So the executor who doesn't want to serve basically just has to fill out a form, and it will depend on the circumstances of whatever's in the will. And then, and if there is no paragraph in the will that says the executor may appoint an administrator, because very often there's wills that do not have that in there. then somebody can just apply to be the administrator. Could be that same niece, you know, she may say, hey, my aunt's declined to do this. She's the only one named as executor. I would like to step in and be administrator. Here are my qualifications. Here's why I can do it. And fill out the application to do that, which is slightly different than just admitting a will. Okay.
So who would make that determination if for example, the niece does that and
Um,
they haven't been named in anyone's will?
Yeah, well, the niece, let's just say it's a niece, because that's a person that's far enough out there that they might even be out of the bloodline. So what you want to do, you will have all of the remaining living heirs of the decedent they have to approve the niece being an administrator. And they have to approve two things. One, that she serves as an independent administrator versus a dependent, which means the court watches everything you do and you have to ask permission for everything. And they also can decide whether or not that person serves without a bond. So they could, you know, the family might say, hey, I don't mind her doing it because she's the youngest one in the family, but I think she should have a bond. So that might be the condition, but that's not the only two scenarios, but that's kind of gives you an idea of what the outline scenarios would be.
Okay, well, thank you so much. That came to the end, pardon me, the end of our questions. I do want to remind people that our next webinar, which Kathleen will be presenting, will be on Friday, April the 25th. And this presentation is going to be about legacy wealth planning. And Kathleen is going to discuss steps that can be taken to protect assets while providing for one's family. And we do already have a link that is live that people can register for. If you go to the haps.org website, and if you go to the HAPS calendar and scroll to the month of April, and on April the 25th, you'll see it with a live link so you can already register. It's going to be from noon to 1 p.m. again. And like this webinar and the previous webinar, it will be recorded and you will be able to submit your questions during the presentation, and then we'll ask Kathleen at the end your questions for any clarification. So I think we're finishing up right around on time. Is there anything that I'm missing, Kathleen? Thank you again. You've done a fabulous job. You always are really good about bringing
Thanks.
things into an easy
I
clarification.
hope so. Yes, I try. So, oh, I do
Do
want to
great.
say one more thing if I
Sure.
could on guardianships. We talked about if you have a POAs, powers of attorney, but then you might have to do a guardianship. If you need to take control of someone's life enough to keep them safe, to keep them healthy, to keep them in a good place, find a good place for them to live and the medical care they need, and you don't have powers of attorney, you are going to have a guardianship. There are other things that you can do that are alternatives to guardianship that you can do ahead of time if you think you're in a situation where you're not going to have a combative patient or principal. There are lots of other things to do that are alternatives to guardianship that I would love to discuss with anybody. Okay.
Honestly, that raises a lot of questions, I know, in my mind.
Yeah, it does. I'm sorry.
As
There
far
are,
as, no,
yeah.
please don't be sorry. I was going to see if we had anything like that. Oh, we do have a couple of questions that came in after.
Okay.
Well, no, actually, I take that back.
Okay.
So, looking through that. Well, again, thank you so much. And thank you everyone for tuning in to watch our webinar. Kathleen Wiesenthal with Keever and Wiesenthal. So I know that you're always available to meet with folks if they're interested. You can always also get in touch with the HAPS office if you would like to get more information about Kathleen. You can certainly look on our website, haps.org. Again, this is a recorded webinar, so you can watch this and you can also watch our previous thing. And please tune in on April the 25th from noon to 1 when Kathleen will present about legacy wealth planning. Thank you, everyone. Hope you enjoy the rest of your day. Thank you,
Thank you all.
Kathleen.
Bye.
Bye.